There is a great deal of misunderstanding regarding the taxation of entities under Subchapter S of the Federal Internal Revenue Code. Today, we will discuss the relative advantages and disadvantages of electing treatment under this subchapter. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. When launching a new business venture, selecting the appropriate legal and tax entity is one of the most consequential early decisions a founder will make. The choice affects not only taxation and liability exposure, but also ownership structure, fundraising capability, and long-term strategic flexibility. Among the various options available to small businesses, the S corporation or subchapter S entity, and I will use those terms interchangeably, presents a compelling option for certain entrepreneurs. This entity type is a tax election under the Federal Internal Revenue Code that enables qualifying domestic entities, which may be corporations or limited liability companies, to benefit from pass-through taxation while still offering corporate liability protections. Perhaps the most attractive feature of a Subchapter S entity is its treatment as a pass-through entity for federal tax purposes. Unlike a C corporation, which is subject to double taxation once at the corporate level, and again when profits are actually distributed to shareholders at the shareholder level, an S entity or S corporation is not usually taxed at the entity level. Instead, profits and losses flow through to the shareholders and are reported on their individual tax returns. This can yield substantial tax savings, especially in the early years of a startup when margins may be slim, and avoiding unnecessary tax burdens is crucial. Additionally, S corporations can reduce self-employment tax obligations in certain cases. Unlike sole proprietorships or partnerships where all income may be subject to the undesirable self-employment tax, Subchapter S entities can divide income between a reasonable salary, which is subject to employment taxes, and distributions, which are not subject to employment taxes, therefore allowing for a more efficient tax planning structure, although this strategy must be used cautiously to avoid IRS scrutiny. An S entity offers the same limited liability shield as a C corporation or limited liability company. I shouldn't say they're identical, but they're really quite similar. Shareholders are generally not responsible for the company's debts or legal obligations, with limited exceptions, which helps protect personal assets from lawsuits, creditors, and business losses. For startups operating in risk-prone industries or with uncertain financial outlooks, this separation can provide significant peace of mind to the principals. Incorporating as a Subchapter S corporation may convey greater legitimacy to customers, vendors, lenders, and potential investors compared to sole proprietorships or general partnerships. The entity must adopt formal governance mechanisms such as issuing stock certificates, maintaining corporate minutes or written consents, and holding annual shareholder meetings to demonstrate a commitment to structured operations, which is particularly important when an entity has elected Subchapter S treatment. This perception of formality can be especially valuable in highly regulated industries or B2B sectors. S corporations also permit fairly straightforward ownership transfers through the sale or gifting of stock, subject to certain restrictions. Unlike partnerships or sole proprietorships, where ownership changes may require dissolution or restructuring, stock transfers in an S entity do not necessarily interrupt operations. This feature can greatly simplify succession planning and investor onboarding, which may be especially important as the business matures. In some instances, shareholders who inherit stock in an S entity may benefit from a step up in basis for tax purposes. This step up can significantly reduce and in some cases even eliminate capital gains tax liability upon a future sale of assets, providing long-term tax advantages in estate planning scenarios. S corporations are, as I alluded a moment ago, subject to rigid eligibility requirements. Most notably, the entity may have no more than 100 shareholders, all of whom must be U.S. citizens or resident individuals. Let me emphasize the word individual. Certain trusts and estates may qualify, but partnerships, corporations, and non-residents are categorically prohibited. These limitations can be especially problematic for startups planning to raise capital from a diverse investor pool or foreign sources. An S corporation may issue only one class of stock, meaning that all shares must confer identical economic rights to distributions and liquidation proceeds. Although there are some very niche exceptions, that is certainly the general rule. This restriction precludes the use of preferred stock or convertible instruments often employed in venture capital financing. Therefore, it can be a significantly limiting factor in the entity's appeal to outside investors. Businesses that anticipate complex capital structures or multiple funding rounds should probably forego Subchapter S treatment for this reason, as they may find this constraint overly prohibitive. Although corporate formalities can enhance credibility and should always be observed in any case, they also impose administrative burdens and costs. Subchapter S entities must hold annual shareholder and director meetings, maintain accurate records of corporate actions, file and maintain minutes, and comply with state-specific corporate governance laws. For founders with limited time, resources, or appetite for formality, these obligations may detract from core business development activities and undesirably increase legal and accounting expenses. The Federal Internal Revenue Service also requires that S corporation shareholder employees receive reasonable compensation for services rendered before taking any distributions. This is a hot button issue. Failing to do so can trigger audits, reclassification of distribution as wages, back taxes, penalties, and interest. Therefore, determining what constitutes reasonable compensation is inherently difficult and requires careful benchmarking, especially in early stage companies where cash flow may be constrained. While Subchapter S entities enjoy favorable treatment at the federal level, not all states conform to these rules. Some states, such as California, impose separate S corporation taxes or minimum franchise taxes regardless of profitability. Others may not recognize S corporation status at all. Entrepreneurs must conduct state-by-state analyses to assess whether anticipated tax savings will materialize, and preferably they undertake this exercise with competent legal counsel. An inadvertent termination of S status can have disastrous consequences. For example, issuing a second class of stock by mistake or transferring shares to a disqualified shareholder can automatically revoke and terminate the election. Once revoked, the corporation may be subject to C corporation taxation for 5 years or longer. Therefore, compliance with these eligibility rules is absolutely indispensable. To briefly recapitulate, choosing Subchapter S taxation status for a startup can deliver compelling benefits, including pass-through taxation, liability protection, and enhanced professional credibility in some cases, particularly for closely held, domestically owned businesses with straightforward ownership structures. However, this entity type is not universally appropriate. Founders must weigh the significant limitations around stock structure, shareholder eligibility, and formal corporate governance against their short-term goals and long-term expectations. Again, my name is Chad Cummings, and I hope you found this information helpful. As always, the information in this video is general in nature and is not legal advice because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier videos, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.